The parents invested $500,000 into the US to get a green card through the EB-5 program back in 2014. Because of the priority backlogs, they themselves eventually got a green card years later, but now their children are over the age limit and their green card got denied. The Child Status Protection Act was not able to freeze their age in time. They were over the age of 21, and so now the parents reluctantly had to just come to the US by themselves. The children were able to still get an F1 student visa to come to the US as a non-immigrant, but it's just awkward because now the children are going through school as a non-immigrant, the parents got a green card when the parents did this whole thing just for the kids. And so it's extremely tragic. And their case was denied back in 2019. Now, fast forward 4 years, we were able to use the February memo in 2023 because the changes in law with the CSPA, we were able to go backdate and freeze the child's age, make the argument, and get them their green card, even though it was already previously denied back in 2019. The family is extremely happy, and let me share with you how we did it. Let's go. Hi everyone, my name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. So the legal problem is that when is this child's age frozen and are they eligible to get a green card? Because their case has already been previously denied, right? So on what basis are you able to apply for it again? Now, a lot of people don't know, you can constantly apply for benefits with USCIS with the consulate again and again, even though they discourage you to because they waste their time to review the case if it's not eligible. But if you have a good argument, if there is a good change in circumstance, if you have a new basis for your application, go for it, do it. Right? We do this all the time with a previously denied EB-1A extraordinary green card case. We reapply, boom, we get it, right? And now with this case, it's because we're trying to argue that this kid's age, even though he's 27 years old now, we can go back in time and freeze his age back 8 years ago because of the change in law and policy. Let me kind of walk you through some of the facts. The kid was born in 1996. So you can see in 2017, he's already turned 21, right? The final action date on the Department of State is available for 2018. And so previously, the law applies that it has to go according to the final action date. And so since he turned 21 in 2017, he just missed it by a year-ish. But the dates for filing chart was only 2015. So it's 3 years earlier. So which date do you use is of critical importance. If you're able to use the dates of filing, well then your age can be frozen in 2015, at which he was under 21. So those were the key facts, but how did we get it and how do we assemble the team to get it done? It was actually quite complicated because there were so many key dates and documents that we needed to get, but it was back like 8 years ago. A lot of times clients don't even have these documents and they don't even know what these documents are. Like what is a DS-260? What is the filing fee for DS-260? Do I have even an email receipt to prove that I did it? A lot of it, you have to go dig back in time. So these clients, they used another law office, they used other agents to be able to do all of this. And they didn't have those files with them, proving that they sought to acquire back in 2015, proving that they got denied for that specific reason and not for any other reason, right? Because if they got denied for criminality reasons, well, the USCIS could still deny them again. There were a lot of internal discussions about how we should craft the brief, where we edited it again and again and again, just so we could get the language correct. And you could say like, it's just CSPA. It's so simple. You just calculate it. Or you just say, they qualify, period, submit. But we didn't want to just do that. We know USCIS officers don't have the time or resources to be trained on every single new memo that gets issued. We see that all the time. And so instead of dealing with the request for evidence or dealing with it at the motion to reopen stage, we wanted to create the best training manual, essentially, for USCIS to train their own internal workforce, right? So we laid out everything as clearly, if not more clearly, than USCIS's own policy guidelines. It was a lot of work. It was a lot of charts. I felt like we were a software engineer trying to, create different Excel sheets and all this stuff, but it was worth it. And we did it for this one case. It was a powerful argument that we were able to make. The clients were extremely happy, and we're glad we made history here. I know people complain about USCIS all the time because they adjudicate cases incorrectly, they abuse their discretion, but in this instance, you can really see that they are trying. Right? The February memo, they don't really have to do it, but they did. And now they issued the August memo. And so you can see that they are trying. If you don't understand what the two memo means, we made a separate video explaining all of that. You can reference it. We used all of those arguments in our attorney brief. And you can just see how this can impact so many people's lives. And so hopefully this helps you. If you have any questions about CSPA, we're creating an entire series explaining every single prong. Hopefully you enjoy it, and if you have any questions, feel free to reach out. Take care. Bye-bye.